single largest instance of Palestinian mass displacement, Gaza, which has left the overwhelming majority of people in Gaza displaced from their homes. Today's guest, Dr. Ardi Imseis, Associate Professor of Law at Queen's University.
We must first disabuse ourselves of this idea that law can deliver justice. Law can be oppressive. Nuremberg laws by the Nazis and apartheid laws in South Africa clash between the European settler colonial movement, supported by the West, and its quest to do away with the native population. From the beginning, the Zionist movement had a problem. How do you establish and maintain a Jewish state in a place full of non-Jews? Demographically, the Jewish state is understood and planned by the United Nations to partition Palestine against the expressed desires of the majority of the population of the country at the time, the Palestinian Arab people. A minority government in place from the start. 43% of the country given to the two-thirds Arab Palestinian majority and indigenous population that had been there for millennia.
Hello and welcome to episode 125 of the Palestine Pod, the weekly podcast where we break down the latest headlines dealing with Palestine from all over the world and bring you stories, commentary, and interviews with the aim of supporting the Palestinian struggle for decolonization, justice, and equal rights. I'm one of your hosts, Lara E. You might know me from Instagram as @GazanGirl, and I'm joined by my co-host, Mikey B.
What's up, y'all? Mikey B on TikTok, Michael Schertzer on Instagram, and you can call me Mikey Intifada if you are scared of a pin and you work for Delta's Twitter department.
Before we get into today's episode, please like, comment, and subscribe if you hang out with us on YouTube. If you're listening on a podcast app, subscribe and leave a review. As always, you can find our full episodes and sources on PalestinePod.com. And if you want to get involved in the conversation, reach out to us at PalestinePod@gmail.com and give us a follow on Instagram @ThePalestinePod. Find us also on Patreon, where you get early access to the Palestine Pod episodes. You'll also get an additional podcast per week. It's called the Patreon Pod. It's a little more laid back. We talk politics, Palestine, pop culture, and get a little more personal. We're also hosting our monthly Zoom happy hours with our Patreon subscribers only. So check us out on patreon.com/PalestinePod. Ardi, how do you pronounce your last name to an English-speaking audience?
The way I would to an Arabic-speaking audience.
Same. Imseis. Okay.
We're keeping that in for sure. Love that.
No, I just want to be sure. I always like to ask people, even if I know or feel like I know, I just prefer to ask.
It's actually a really good question, because as a kid, my grade school teachers would call me all manner of things, but mostly Imseis. And, we became used to it. And then afterwards, my grandmother would say, it's Imseis. Thanks very much. So, halas, it's Imseis.
Imseis, absolutely.
Then that's how we'll Imseis it.
Today's guest is Dr. Ardi Imseis. He's Associate Professor of Law at Queen's University. In 2019, he was named by the UN High Commissioner for Human Rights to serve as a member of the UN Commission of Inquiry into the Civil War in Yemen. Between 2002 and 2014, he served in a senior legal and policy capacity in the Middle East with the United Nations Relief and Works Agency for Palestine Refugees in the Near East, otherwise known as UNRWA, and also the UNHCR, the United Nations High Commissioner for Refugees. He's provided expert testimony in his personal capacity before various high-level bodies, including the UN Security Council, the UN Human Rights Council, and the UN Committee on Economic, Social, and Cultural Rights. Ardi, you are actually, I've read your entire bio, but it doesn't say the main thing that we're here to talk about, which is the book, The United Nations and the Question of Palestine, Rule by Law and the Structure of International Legal Subalternity. I have the book here. I've just finished reading it, and so it's fresh in my mind, hopefully for a very good discussion. If I were to describe it by giving sort of like the main theme of the book, I would say that the book really tells a story of how, since the inception of the UN, even going back to its predecessor, the League of Nations, Palestine and its people have been denied their human rights in a systematic manner that is now in its 76th year. And this, of course, is in stark contrast to the UN's role in supposedly guarding international law. In telling this story, you coined the term international legal subalternity to describe this legal condition that Palestinians find themselves in. So my first question to you is, what does international legal subalternity mean? And in defining it, can you give us an example of one of the key events where we see this condition materialize?
Sure. First of all, Lara, thank you for having me. Michael, it's good to see you. You put it well in your question. Legal subalternity, the term that I coined, the essence of it is that the international community, through the United Nations, which is the preeminent international organization in human history, really. It's unprecedented in terms of what it represents in our story as humans on planet Earth, holds out international law to the Palestinian people as offering respite, as offering a road to justice. And if only the Palestinians reach for and agree with all of that, justice will be had. And yet, at every moment that the Palestinians do this, the goalposts seem to shift. So it is the promise of justice through international law made, but then constantly withheld through, ironically so, paradoxically so, the actions of the very same purveyor of that promise, being the United Nations. And these actions can be positive, direct actions, or negative, like omissions, things that the UN either does or does not do when it comes to the application of public international law in the question of Palestine. I tell this story, and as I was doing the research, looking at the UN's management of the question of Palestine from 1947 to the very present over this 76-year period, I noticed these patterns. They pointed up this condition. Palestine and the Palestinian people are not unique in this respect. There are other legal subalterns in the international plane, say indigenous peoples, non-self-governing peoples, refugees, IDPs, or internally displaced persons. There's all manner of different legal subalterns for whom the promise of international law and justice through the United Nations has never truly been realized, or is in the process of being realized, but not quite. And yet I find that Palestine embodies this condition better than most, and it's simply because of its longevity on the agenda at the United Nations. The UN was formed in 1945, and the question of Palestine has been on its agenda since virtually the beginning of the organization. And while that organization has changed over time in terms of its political contours, for instance, in the early years of the organization, it was largely dominated by Western states. The General Assembly, the plenary body of the organization, then had about 51 states, the vast majority of whom were Western, former colonial powers or colonial and imperial powers on their way to decolonization. And through the decolonization period, the 60s, the 70s, Asian states, the Latin American states, the African states, and so forth were emerging as independent from the yoke of colonialism. They began to change the face of the United Nations, whereas today, over 2/3 of the United Nations are from the global South. One would have thought that through the decolonization era, the Palestinian predicament would somehow have gotten better, and it did to a certain extent. But those conditions of legal subalternity remain, as I identify in the book, all the way up to the present moment, where we have a unipolar world now moving into a multipolar world again, but largely dominated by a great power, the United States, who uses and abuses law, including law based in the UN Charter, to foist and push hegemonic positions, and to the detriment of the Palestinians, but not just them, many others.
What is one of the key events where you see this condition materialize?
On key events where I see this condition materialize, the book covers various moments in time. 1947 and the UN's purported partition of Palestine. Next, I deal with the UN, the fallout of the partition resolution being the creation of the Palestinian refugee problem and the United Nations response to that in the creation of a unique normative and institutional regime devoted to the Palestinian refugee problem, being UNRWA and the United Nations Conciliation Commission for Palestine, as distinct from UNHCR. And then I move forward in time. I deal with the UN's handling or mishandling, if you like, of Israel's foreign military occupation of the West Bank, including East Jerusalem and the Gaza Strip, since 1967. And then finally, I move all the way up to another moment, if you like, in the UN's handling of Palestine, or the state of Palestine's application for membership in the organization in 2011. And through covering each of those moments in time, the theme of legal subalternity appears and reappears and is produced and is reproduced by the United Nations and its decision-making. But I suppose if I had to think of one moment, one of those key moments that sort of set the stage, it would definitely be the decision of the General Assembly of 29 November 1947 to partition Palestine against the interests and the expressed desires of the majority of the population of the country at the time, the Palestinian Arab people. Why is that the case? Well, all one need really do is look at the terms of the resolution plan on their face and what the UN record reveals, not only about those terms, but about what states and those persons who were responsible for fashioning that plan in the United Nations Special Committee for Palestine majority said and did as they considered what the answer to the question of Palestine should be at the time. And those terms are, on their face, very clearly violative of prevailing international law as it stood in 1947. So what are those terms? Well, in broad strokes, they're both demographic and territorial. So territorially, the country was split up into a Jewish state and an Arab state. The Jewish state was given under the resolution 56% of the total of the country, even though the Jewish population, the settler population of that country, that had only been in the country for about 30 years at most, 40 years at most, comprised only 1/3 of the total of the population of the country. You had 42 to 43% of the country given to the 2/3 Arab Palestinian majority and indigenous population that had been there for millennia. And demographically is also an interesting thing. Although the partition resolution passed by the General Assembly, Resolution 181 of 29 November 1947, required that both of the envisioned states be democratic, adopt democratic constitutions, and ensure rule of law and equality before the law of all peoples in their territories. The population numbers as envisioned by the partition plan didn't add up. Why? Well, in the Arab state, there was going to be a clear Palestinian Arab majority, very, very clear, overwhelmingly clear. 95% of the population of that country or more would be Palestinian Arab, so there wouldn't be a problem. But demographically, the Jewish state, as understood and planned by the United Nations, actually had a minority government in place from the start. That is to say, the population of the purported Jewish state or proposed Jewish state from the off was to be 509,000 Arabs to 499,000 Jews. And this, despite what the United Nations said in the General Assembly resolution, should be a democratic state. However, could it be democratic if minority rule was to prevail from the off? At the same time, we mentioned territory. The Jewish population of Palestine at the time only owned 5.6% of the total of the country, and yet were handed for 56% by the United Nations General Assembly. Why does all of that matter? Well, the Palestinian population made it very clear that they believed in democracy, that they believed in the idea that they should be given their independence in line with the League of Nations Covenant, which they had in place for some 30 years, the so-called sacred trust of civilizations that was bestowed upon Great Britain as the mandatory power, which required that they be given their right to self-determination, or that their right to self-determination in their independent state of Palestine be realized as rapidly as possible, as was done in other mandated territories under the British and the French in the region, Lebanon, Syria, Iraq, and other places. And yet, despite all of that, the United Nations General Assembly pursued with a plan to dismember Palestine against the interests and willingness of the Palestinian indigenous population, with consequences that remain with us to this very day. 3 days after the passage of that resolution, a civil war broke out, as you well know, Lara, during the first 6 months of which some 300,000 Palestinian Arabs were ethnically cleansed. And once Israel proclaimed its quote-unquote independence, a unilateral declaration of the establishment of the state on May 14, 1948, and the onset of an international armed conflict when the Arab states surrounding this new state of Israel entered Palestine to save it from dismemberment. The war continued for another 12 months or so, wherein about 450,000 to 500,000 or more Palestinian Arabs were further ethnically cleansed. And the results remain with us to this very day. But why does this matter in terms of legal subalternity? Because all of this ran counter to prevailing international law at the time. The right of self-determination of the Palestinian people, the majority of the population of the country, as affirmed and established years prior, decades prior, in the League of Nations period and through the League of Nations system. And it set in motion the so-called two-state framework, which remains in place to this very day, basis of the international consensus, as it is called at the United Nations, on how peace should be brought about between Israelis and Palestinians in that land. And notwithstanding all of these messages and all of this consensus, the Israelis continue to take more and more of the land and commit more and more atrocities in an attempt very clearly to rid the land of its native population.
You speak of how the partition plan itself ran against the prevailing international law of the time. If that international law is supposed to represent these rights from which we cannot, in principle, derogate, what were some of the discussions like on why partition had to take place in any event, in total contravention to the international law, which should have been applied? And maybe I'll also just say that as I was reading the section of the book that discusses this in detail, it was startling to me to see how Palestinians and their allies at the time, some of the other Arab states that were participating in these discussions at the United Nations, are actually the proponents of democracy and are saying, no, 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 we have to apply democratic principles. We have to apply majority rule. We have to apply the principle of self-determination of peoples from which we cannot derogate. And the so-called powers that be, in response, propose solutions which are completely illegal and uphold completely undemocratic principles.
And maybe we can define derogate for people who prefer audiobooks and TikTok.
It's not that complex.
Oh, yeah, I know what it means, obviously. I'm just, for other people.
This idea that there are rules from which there can sometimes be exceptions to those rules, but there are certain rules from which there can never be any exception. Current context is the right to be free from genocide, right? There's no exception to committing genocide. So the right to be free from genocide is a rule from which, or is a right from which, there can be no derogation. So that's really the idea.
Thank you very much for the question, Lara. I'm very grateful for it. So during the course of the deliberations of the United Nations Special Committee on Palestine, which examined how to deal with initially what was called, and I'm quoting, the future government of Palestine, which was the question that was handed over by the British to the United Nations General Assembly, but then was morphed by the body that mandated UNSCOP into the so-called Question of Palestine, not merely the future government of Palestine. This was politically morphed by Western states. And the reason behind that, incidentally, was to ensure that UNSCOP's mandate, its terms of reference, allowed for things more than merely discussion of how Palestine was to be governed in future, because that implies an independent state of Palestine, that Palestine would be a unitary whole. They changed that question, future government of Palestine, to the Question of Palestine, in order to enable discussion of partition. If you look at the UN record, as I did, on what UNSCOP and its membership considered, who they spoke to, what their deliberations revealed in their private and public record, you see that they were not motivated at all by international law or what international law required vis-a-vis the Palestinian indigenous population and the right of self-determination and majority rule and the sacred trust of civilizations. Quite the opposite. They were motivated by one thing. And remember, this is the Western-dominated United Nations, majority of them being Western states, that motivated by resolving the quote-unquote Jewish question. Their words, not mine, was viewed as a form of recompense without any regard whatever to the non-European society that was being bludgeoned by the imposition of this settler colonial regime. So that is in effect what is in the record. And what I can do is recite for you and your listeners some of the key quotes. Take, for instance, the UNSCOP Majority Report in 1947, which recommends to the General Assembly partition. With regard to the principle of self-determination, although international recognition was extended to this principle at the end of the First World War, and it was adhered to with regard to the other Arab territories, and they're referring here to Iraq, Syria, Lebanon, and so on. They continue, at the time of the creation of the A mandates, it was not applied to Palestine, obviously, because of the intention to make possible the creation of the Jewish national home there. It may well be said that the Jewish national home and the sui generis, or the unique, mandate for Palestine run counter to that principle, run counter effectively to the principle of self-determination. So UNSCOP is from the off, as a matter of public record, saying self-determination is a principle. We're not going to apply it in the question of Palestine. We're not going to apply it to Palestine because of the presence of the Jewish population there and the Jewish national home policy of the British. And then you see more of this, if that doesn't sort of stop the majority of UNSCOP in its tracks to get some of these men thinking about problems that they may produce through adhering to this position. What you see is even more affirming position of this anomaly given by Jorge Garcia Granados, then the permanent representative of Guatemala to the United Nations, before the General Assembly, when it was just nearly weeks after having received the report from UNSCOP and the recommendations for partition, when he was arguing that partition was a good idea, and incidentally, he himself was also a member of UNSCOP, he told members of the General Assembly, and I quote, "Palestine was no more Arab than certain Spanish countries of Latin America were Indian. The Jews had made a pleasant and healthy country out of a land in which a sparse and rachitic population had merely vegetated. It was incomprehensible that the Arabs should adduce their numerical superiority as an argument. An ignorant majority should not be allowed to impose its will." And I end quote there. And so you can see a quickening sense among some in the Western states, the dominant party in the United Nations at the time, of their goal of resolving the so-called Jewish question at the expense of the non-European Palestinians. They're open about it. They're public about it. International law is thrown under the bus, as are the Palestinian natives of the country, and we are left to deal with the consequences of it.
I would love to, in contrast to the quote of the Guatemalan representative, read out the quote of the Cuban delegate.
And if I might, Lara,
Yeah.
if I might, this is the Cuban delegate before the revolution. This is before Castro's revolution. This is the Batista government. Go ahead.
So he says, "We, the UN, have solemnly proclaimed the principle of the self-determination of peoples, but we note with alarm that when the moment comes to put it into practice, we forget it. This attitude seems to us highly dangerous. The Cuban delegation is firmly convinced that true peace and the international justice about which the great leaders of the Second World War spoke so often cannot be brought into being by setting forth certain fundamental principles in conventions and treaties and then leaving them there as a dead letter. On the contrary, these ends can be attained only if all of us, great and small, weak and strong, are prepared to put our principles into practice when the occasion arises. Why was the democratic method of consulting all the people of Palestine not applied in this case? Is it because it was feared that the results of such a procedure would be contrary to what it was intended the outcome should be in any case? And if that is so, where are the democratic principles which we are continuously invoking?" The idea here being that they had already decided what they wanted to do. And so it was just a question of how are we going to arrive at that result? And the only way to arrive at that result is by circumventing international law. Because if you apply international law, you're supposed to get another result, which is actually to honor the majority will in Palestine at the time, and that was for a democratic rule. But when Palestinians proposed that solution, they were told that they were being, quote, extreme.
And those were the words of a representative of a US-backed dictator. You got to imagine that guy got recalled from his job.
So in that regard, you say UNSCOP understood the Arab position to be one of establishing a unitary democratic state based on proportional representation, the gold standard of democracy by any measure at the time. It curiously rejected this position as extreme because it would have left the Arabs substantially in control of the country.
So you mentioned how the majority Arab population, the Palestinians, did not want the land colonized. Can you imagine? What a shock. That was also the opinion of Jews in the United States for some time at the first Jewish Labor Congress, a 1919 national gathering in New York of representatives from Jewish-led unions claiming to represent 500,000 workers. The delegates debated Zionism and passed a measure that explicitly rejected the idea of a Jewish state in Palestine. Instead, the resolution called for the establishment of, quote, a free, independent republic in which no nationality, whether a minority or majority people, shall have any special rights, end quote.
Yeah, and what that demonstrates, Michael, is that there has historically been a very large segment of the Jewish population in the diaspora and even in the Middle East that are anti-Zionist. And so it points up a similar theme that has continued from those days and straight through the present. In the end, both of the comments that you both offered now, Lara and Michael, point up the essence of what I'm trying to pursue in the book, which is to interrogate the disconnect between principle held out by the United Nations, or in this case by hegemonic power, principle like democracy, self-determination, human rights, and so on, and action on the other, which runs counter to that principle. What happens when decisions are made on the basis of pragmatism, realpolitik, brute force? And if what happens is negative, then what does that mean for the international rules-based legal order? What does that mean for international law? Lara, I was reminded while you were speaking, if you look at the UN record and see what the Arab and the Palestinian position is on partition, on future Palestinian state being democratic and a state for all of its citizens, whether Muslim, Christian, or settler Jewish. There's a very magnanimous position taken by the Palestinians and by the Arabs, one that is supportive of these principles of democracy, of self-determination, of human rights, and so on, flouted very clearly by the hegemonic powers that be, the Western powers, the majority of UNSCOP, and so on. There was an attempt by Syria and Egypt to put the partition proposal to the International Court of Justice for an advisory opinion on whether or not it violated international law that prevailed at the time. And a vote was taken by the General Assembly, then Western dominated, and you can guess how that vote turned out, that they chose not to submit the question to the International Court of Justice, for fear that had they done, just like the Cuban representative mentioned, the court would have come down with an opinion that ran counter to what was already planned, if you like, by the majority of UNSCOP and indeed the majority of the General Assembly.
Yeah. Hey, if there's always been anti-Zionist Jews, why do I feel so alone?
The partition plan sets into motion a chain of events which brings about the Nakba of 1948. And I would like to share just a couple of paragraphs in your book summarizing the Nakba, because I think it's really important, especially as we consider what's happening on the ground today in Gaza. You write, the manner of Palestine's ethnic cleansing consisted of innumerable acts of widespread and systematic violence aimed at expelling or encouraging the mass flight of the indigenous population from the country. This included indiscriminate bombardment, siege, and expulsion of the Palestinian Arab population from cities, towns, and villages, at least 31 confirmed massacres of civilians, including the use of mass graves as means of concealment, rape and other forms of sexual and gender-based violence, psychological terror campaigns broadcasting horrors to befall the population if it did not flee, biological warfare, and a host of scorched earth tactics, including the deliberate destruction of between 392 and 418 Palestinian villages, whence at least half of the refugees were expelled. As the ethnic cleansing was unfolding, and well before the last armistice agreement was signed in 1949, the Israelis further consolidated their conquest by seizing, looting, and settling Palestinian refugee and state property. On the eve of the Haganah offensives under Plan D in April 1948, David Ben-Gurion, Israel's first prime minister, said that, quote, "We shall enter the empty villages and settle them. In peacetime, we would not have been able to do this," end quote. Accordingly, Benny Morris reports that about 135 new Jewish settlements were established between the start of the hostilities in November 1947 and the end of August 1949, and that most were established on Arab-owned land and dozens were established on territory earmarked by the UN partition for the Palestine Arab state. Tens of thousands of new Jewish settlers were moved by Israel into Palestinian Arab refugee houses that remained intact. Although the magnitude of the dissolution of Palestine and its ethnic cleansing goes well beyond the pecuniary, the monetary value of Palestinian losses suffered as a result has never been fully accounted for. And then you go on to give some estimates of what these losses might entail. So there's a couple of questions I have with respect to the Nakba, and let's treat them, I guess, in order, by starting first with the facts. As we're considering what is happening today in Gaza, many of us have commented that what we're really seeing is just an extension of the Nakba, which began in 1948, but which never ended, and for which there has never been any sort of accountability under international law. So my first question goes to the relationship between impunity in the case of the international wrongs that were committed during the Nakba in 1948 and this condition of legal subalternity that persists until today. Can you speak about what impunity does to a people and why accountability is so important?
There are a few things that anybody who engages with the Palestinian people, outside observers, will notice about the Palestinian people, aside from their great hospitality and their great joie de vivre and their quest and lust for life, and the product clearly of their suffering and their history. They're also a cynical people. I grew up in a household where I was reminded that power is everywhere and that the gig is on. Like, you can't trust power. It's constant, it's everywhere. And there is a cynicism that prevails from school children all the way up to the elders. Cynicism about how the world operates. And this cynicism leaks into their perception of justice and law. And so everything you've just described, which I cover in my book, in those paragraphs, as I read back after the 7th of October, because I wrote it well before the 7th of October to be sure, is being replayed before us right now in the Gaza Strip. And without any serious attempt by any states, by any international organization to seek redress and to ensure accountability for it. There are some attempts clearly at the International Court of Justice. I'm working, as you well know, on a few cases there, including the advisory opinion that will be issued by the International Court of Justice on the legality of Israel's presence in the occupied Palestinian territory, Friday the 19th of July. But those aren't enough. There is no measure of international law that can be thrown at the Palestinian people now and give them the justice which has so long been withheld from them. Accountability matters. The hope rests in that. People like you, people like me, and others. They don't have economic power. They don't have political power. What they do have is their moral high ground and the morality and the legal positions that they have under international law. And in the absence of accountability, the persistence of impunity over time, the situation just gets worse and worse. And notwithstanding all of that, and notwithstanding even the cynicism that I'd mentioned, there are many of us in the Palestinian community that look to international law as being one of the bases can seek redress. And this is the paradox in the situation.
So the second part of my question goes to what you address at the end of the passage, which is this notion of reparation. So for people who are not public international law experts, can you just generally describe what obligations a state has for its internationally wrongful acts? The principle set out in the Harzo factory case, and how that would apply to Palestinians if the law that exists in the books was actually being applied to us as a people, and if our rights were not continuously withheld, as is the case given this subaltern status that we find ourselves.
Yeah, look, being more technical, your question invites a technical response. The international law of which you speak now is the law of what we call responsibility, or the law of state responsibility, where a state engages in an unlawful act. The term of art is internationally wrongful act. There are three obligations that state has. The first obligation is to cease that act. These will be intuitive to your listeners. They must cease the act, so the obligation of cessation. Second, they must give appropriate assurances of non-repetition of that act. And finally, they must make appropriate reparations, which can include return of property lost, or return of bodies, refugees, for instance, to the territory that they were ethnically cleansed from, or what have you. It can include an apology, and oftentimes where there can be no material reparations given because the material in question is lost, say dead people can't be brought back from the dead. And then financial compensation. And looking at what took place in 1947, 48, 49, like that part of the Nakba, if you like, the international community spent no time at all. The United Nations spent no time at all trying to ensure that the authors of the Nakba abided by their obligations under international law. First and foremost, not to denationalize the population of the newly formed state of Israel wholesale, to ethnically cleanse that country, that newly formed state, of its indigenous Palestinian Arab population, to drive them out, to forbid them from returning because they're not Jewish, which is clear discrimination, and then to usurp their property from them and to denationalize them. You can't, on a change of sovereignty of a territory, the new sovereign, as it were, is not allowed to denationalize its population. This is illegal under international law. And the international community did nothing. The UN did nothing to press those basic core principles of international law as established in the Horizal factory case, to press those against Israel at the time. And this continues right up to the present, where law is being used and abused by the occupying power. The Israelis have control over the skies of Gaza. They are discharging their weapons and their bombs on that population, and in a way not seen this century. Results that are very, very clear for all to see. Tens of thousands possibly dead under the rubble, presumed dead under the rubble. Those who will die in the future by virtue of the war that is depriving them of the most basic things for their sustenance, and then the over 100,000 that have been injured. All of that is being done under color by the occupying power of some legal right, whether a purported right of self-defense, which they don't enjoy under international law. Paragraph 139 of the 2004 Wall opinion of the International Court of Justice on that, if you're interested, or a right to deploy force. There's no place to hide. It is so densely populated. Israel's obligations to distinguish between the combatants and the civilian population that they deploy their weapons against. So you see there's an impunity that continues there as well, and the rules on state responsibility being flouted left, right, and center. There are some attempts now at the International Court of Justice that I'd mentioned to call attention to that, including this case on the illegal occupation.
You speak about how there's these efforts that are ongoing right now to promote accountability under international law for Israel's violations of international law, some of them including the two ICJ cases which are currently pending, one on Israel's violations under the Genocide Convention, the other being in relation to the legality of Israel's presence in the so-called occupied Palestinian territories, and also even the attempt that is ongoing right now before the International Criminal Court. We heard a couple of months ago, I think it is now, that the prosecutor Karim Khan has asked the judges for the issuance of arrest warrants with respect to Yoav Gallant and Netanyahu. My feeling about all of this is that even if, let's say in the best case scenario, all of these efforts result in the best possible decision for the Palestinians, whatever it may be. So the ICJ finds that Israel has breached its violations under the Genocide Convention and has committed genocide. The ICJ finds that Israel's presence in the OPT is illegal and orders its immediate withdrawal. ICC finds that Yoav Gallant and Netanyahu have committed war crimes, crimes against humanity, and tries to arrest them both. There still remains this idea that the totality of the Palestinian lived experience and the totality of the injustice that Palestinians have suffered for the last 76 years will still, in a sense, be fundamentally unaccounted for. And I feel like a lot of what we're seeing right now, because of the shifting goalposts as time goes on, has resulted in the attempt to seek accountability for these discrete actions, these discrete wrongs that are taking place at a discrete point in time, but it's sort of divorced from the entire story and the entire lived experience of Palestinians. And so I wonder, now 76 years into this saga, if you see that there's ever going to be a potential route for Palestinians once and for all to seek redress for the totality of wrongs to which they have been subjected to. And in answering this question, I want to focus in particular on the right of return, because I think that that is one of the principal rights which has been violated and continues to be violated. And it's one of the violations which has been the most long-standing, right? It's generations long. And it's continuing in nature. So you have Palestinians who were expelled in 1947, 1948, 1949, 76 years ago. Palestinians who were expelled and prevented from returning every single year in between. And now in this current moment, the single largest instance of Palestinian mass displacement, which is taking place in Gaza, which has left the overwhelming majority of people in Gaza, 2 million people, displaced from their homes. Now, at this moment, the majority of Palestinians remain in Gaza, but the question still remains to be seen whether they too will be added to this history of Palestinians who have been uprooted from the land of Palestine and therefore prevented from returning.
A very prescient question. I suppose the first place that I typically begin when I'm asked similar questions is to remind my audience that law has its limits. We must first disabuse ourselves of this idea that law can deliver justice. They're two different things, of course. Law can be oppressive, and indeed it has in the past. My whole book is about that. But looking at other examples, the Nuremberg laws passed by the Nazis in Nuremberg in the 1930s were clearly laws, but they were oppressive. The apartheid laws in South Africa were laws, but they were oppressive. And so law can be used to bludgeon and so on. Question is, can law be used to liberate? And this is part of the need to disabuse ourselves of the view that law can liberate. Law can be part of a process of liberation. Law in this process is but one of many different tools in the toolbox of liberation. And those tools can include, among other things, the political, the cultural, the scientific.
I'm a big fan of the gun.
Yeah. They indeed, that's no joke, Michael. They also do include the military. All this to say, law is can potentially be part of a liberation movement, but we must disabuse ourselves from the off of the belief that somehow law can liberate. And once we do, then we're better able to see the value and the limits of law in this process. Now, you'd mentioned a number of different cases, the ICJ case, the advisory opinion on the legality of Israel's presence in the occupied Palestinian territory. There's also the series of genocide actions that are taking place. There's the ICC process. Now, as lawyers, you and I will both know that there are limitations to each of those cases. So, for instance, as you've mentioned, let's suppose that 5 or 6 years hence, the International Court of Justice rules that genocide did take place or has taken place in Gaza. Will that bring back those who've been killed? No, it won't. And your viewers will now, having listened to me just 15 minutes ago, know what the law on state responsibility requires of a wrongdoing state that has committed genocide, to cease the genocide, to make appropriate assurances of non-repetition for the genocide, and to make reparations for the genocide. That's as far as it's going to go. That's as far as law will take us. And that's clearly not enough. On the illegal occupation case, it's a little bit more considered. That is to say, if the court does determine that Israel's very presence, it gives rise to all of these discrete violations of human rights and humanitarian law, hundreds and thousands of them, if really over many, many decades. If they declare that the occupation is illegal, then the occupation must end forthwith and unconditionally and as rapidly as possible and so on. But does that treat the refugee problem? Does that treat the more structural aspects of the clash of settler colonialism on the shores of Palestine and how it has ravaged the people of Palestine? Clearly not. And so we must look beyond law for that. Understand the limits of law, understand law's utility, especially in giving rise or going for and trying to get justice for all, universal justice for all, without regard to their race, class, religion, etc., gender, and so on. Now let's shift to the question of the refugees. It produced the refugee issue, but it's a problem where there's a clash between the European settler colonial movement, self-described, supported by the West from beginning to the very present, and its quest to do away with the native population in this non-European place. What it has produced in 1947, 48, and 49 is the Palestine refugee problem. And the two-state paradigm, which I spoke of earlier, doesn't address that in any real substantive way. And the law that exists that does address that is international refugee law, international human rights law, and that law is very clear. Palestinian refugees have a right, among other things, to return to their homes, their lands, their properties, inaccessible to the Palestinian refugees because they're forbidden from returning to it by virtue of the fact that they're not Jewish, so immutable characteristics. They can't change the fact that they're not Jewish, but they're unable to return to it because they're not Jewish. And that property has been usurped by the state and transferred by the state of Israel to quasi-governmental bodies like the Israel Lands Administration or Keren Kayemet LaIsrael, the Jewish National Fund, for ostensibly public purposes, which are synonymous in Israel and in Israeli law with Jewish purposes. So that property is handed over to Jewish Israelis for Jewish settlement and so on. Even to this day, people find it odd that you can't buy a freehold property, even if you're Jewish. The only thing you can purchase is a leasehold right, a right to lease the property for 99 years from the Israel Lands Authority or the Jewish National Fund or the Israeli government. One wonders, why ever would you not be able to own the property? Why only would you be able to buy a lease right? And the idea is that under Israeli law, that property stolen wholesale from the Palestinian refugees belongs under Israeli law to the Jewish people in perpetuity. So you buy a lease right that you can't transfer ownership on except lease right.
And I want to say that was always the plan. Like, you see, there are some people online right now trying to take the revisionist route. Like Zionism started off nobly and it's somehow gone astray. It's like an accidental morph into a genocidal ideology that has now murdered over 186,000 Palestinians, stolen the majority of land in Palestine, and as well as large swaths of Lebanon, Jordan, and Syria. That it really could have gone either way. And this is, of course, an absurd, ahistorical, dishonest take that we see propagated by even so-called some Palestinian allies. Fortunately for historians and people of conscience, Theodore Herzl wrote in his diary in 1895, quote, "When we occupy the land, we shall bring immediate benefits to the state that receive us. We must expropriate gently the private property on the estates assigned to us. We shall try to spirit the penniless population across the border by procuring employment for it in the transit countries while denying it any employment in our own country. The property owners will come over to our side. Both the process of expropriation and the removal of the poor must be carried out discreetly and circumspectly." Also, in 1948, the head of the Jewish Agency Population Transfer Committee, Joseph Weitz, met with Zionist terrorist leaders at the time and said, quote, "I made a summary of a list of the Arab villages, which, in my opinion, must be cleared out in order to complete Jewish regions. I also made a summary of the places that have land disputes and must be settled by military means." In 1936, Maurice Hexter, an executive at the Jewish Agency, explicitly stated the goal of the Jewish Agency was to, quote, "the herding together of the existing Arab villages and their concentration in order to evacuate their territories for Jewish colonization, force the people to exchange land and move from one place to another. Our intention is that Jewish settlements will be for Jews only." Sounds like a policy written by Ben-Gvir yesterday.
Yeah, in a very real sense, Michael. Therefore, when we listen to Ben-Gvir and when we listen to Smotrich and when we see what they represent, because they're not some outliers, they're representative of a very, very large number of Israeli Jewish population. These people are logical, they're clear-minded, and they demonstrate a fidelity to that which they've inherited, all of that which you've just mentioned. And this fundamentally goes down to what Benny Morris, in one of his writings, and he's no friend of the Palestinians to be sure, made it very clear that from the beginning, the Zionist movement had a problem. The problem was that how do you establish and maintain a Jewish state in a place full of non-Jews? And the process, of course, is what we have seen and witnessed in the lived reality of the Palestinian people since 1882 and up to the present. And it is a process that you describe, that others have described for you and for us in the Zionist Israeli record, to displace and to replace the Palestinian people on the land. And that is what we're seeing today in the Gaza Strip and elsewhere. In a speech that I gave before the General Assembly of the United Nations on this past Nakba commemoration of the 76 years of Nakba, I made a point of quoting Patrick Wolf and saying that the Nakba is not an event, it is a structure. And what you've just described and what we've been discussing, even these discrete pieces of law and these discrete moments in time, 47, 67, 2011, and so on, all of that is embodied in the structure.
Is there any other question that you want me to ask you that we haven't covered? Anything else in the last couple minutes that we have?
I mean, not really. I'm rather pleased with the way things have gone. There have been moments where I've been a bit too verbose or not clear. The second to last answer, I think, was...
You're very hard on yourself. I would beg to disagree, but...
Oh, well, bless your heart.
Oh, wow. A lawyer disagrees.
Yeah. Thanks, guys. I appreciate that.
Folks, that's been another episode of the Palestine Pod. Go ahead and check out our full episodes and sources at www.palestinepod.com. Follow us on Instagram at @thepalestinepod. Send us an email at palestinepod@gmail.com and look for us on Patreon, www.patreon.com/palestinepod. That's been another episode of the pod. Thank y'all so much for listening. Have as good a day as you can. We can start telling people to join the Patreon. The show wouldn't be possible without a Patreon. You got to get on our Patreon. Support us on Patreon. You can, because I've been watching all these other podcasts and they just keep plugging Patreon all the time. Yeah, I'm going to clip what you just did right now.
Okay.